Hello? Nothing? Yeah, she's okay writing exams. Maths, she was a bit stressed because she couldn't access the exams, and then she lost time, but they allowed her to do the next session. But she says that the paper was very, very long. They only gave them like 30 minutes, whereas it was like a 60-minute paper. So I think she didn't complete some sections. Yesterday's paper, she said she finished early. It was good. Tomorrow, tomorrow she got EMS. Yeah, I checked it. You're talking about this instruction? Yeah, I gave it to you already. Is the client here? Because I got my course on now. Starts at 9 o'clock in like 4 minutes time. When you told her to do it? So what you think it would have been stored as? What you wanted her to do? Because I don't see anything done like there's only two things I can see stored for 2024. One is a notice.
They're not coming in.
Yeah, no, I don't think it's stored yet. Okay.
I don't know if you're gonna have a chance, but it's the appointment is only on the 28th of May. If you could possibly check this.
Okay.
Morning, welcome.
So where should I put it just in case? Maybe tomorrow.
Where's the file?
I have the file also.
Then leave it in the file. Should be on Monday.
Okay.
Let me check in if Matima is here. If Matima is here, then we are all here. Whoever is not here, Matima will represent.
Yeah, but I told you he's coming in. Okay, can you draft something? Can you draft something now? Draft something? We need to.
Well, in class, everybody is coming in. One is coming in with a fancy cup of coffee as well. Yeah, wow. I hope online you also have fancy cups of coffees. We have done module 1, the intro to law module. And what we suggest we should do is this month go through each module, at least chapter 1, chapter 2 of those, finish it so that you get to know what is in these modules. Next month, we then go according to the timetable and follow each day as the timetable would say, because then you would have seen all the modules. You have now seen module 1, the law module, and you've enjoyed working around it. Let's look at what's inside the second module then. Please, if you have module 2 with you, let's go through module 2. If you don't have it with you and you're online, you'll be able to follow through mine, but you can also find the same module on eLeader. It's available. And those in class, I see they have it in front of them as well. I'm going to take you through this module, and I'm hoping by today we should have at least done the basic introduction on it. And next week we do the other introductions on the other two, so that when April comes, we've covered every module. And by that time, we'll be actually able to give you the assessment instruments. You can start doing first activities on each and every module, actually, as a matter of fact. Just adjusting projector in class. I'm with you if you hear me quiet. Projector adjusted as best as we could. We are now looking at module 2, professional conduct. Yes. When we go through these other modules, including this at some point, you're going to see that I'll start putting on Standiwe, Kotatso, and Marilyn will be sorting out your WhatsApp groups so that they can put you in different WhatsApp groups. And then once you're in those groups, you'll be able to access some of the material on WhatsApp quicker than you would access it through email and other means. But we'll also make that material available on eLeader and other platforms for you to be able to get hold of it. So the reason I'm bringing up that issue is some of the material that we will use to support the learning, it will be material that we'll make available for you. We'll probably make one page of this, or a picture of this, or a video of this, so that you can actually get hold of this material. If you look at how the material is written, it's written in terms of the unit standard, and it follows the SASITA unit standard the way it was designed, but it's not always meaty. Sometimes it's just bones only. And you need more information. And also, if you look at the learning material, you'll see at the later stage that some of the issues may be outdated. For example, they'll call Law Society trying to say the Legal Practice Council. And we didn't change that. We let it be because it will help you with the historical background of things. So if you understand that the law societies were now changed in terms of the Legal Practice Act into the Legal Practice Council, and the Legal Practice Council is now taking foot to regulate the legal profession industry. You will then understand the background. But if you don't have the background, you would probably meet a judge or an advocate or somebody who's been old school and says to you, have you done this at the law society? Even at work, somebody says, go find this document for me at the law society. And you come here to the law society and they say, no, not that law society, the other law society. And they actually would be referring to the Legal Practice Council. So you need to know that there's that thinking. All right. So speaking of the Law Society and the Legal Practice Council, the Law Society used to regulate conduct of legal practitioners and the different law societies. Today, you're looking at this, it's in the Legal Practice Act. So next time we sit and we have a discussion on this, I will have asked that you go home and find yourself a copy of the Legal Practice Act, So write it down, find the Legal Practice Act, and also find the Attorney's Code of Conduct. So those are the two things you are going to find: the Legal Practice Act and the Attorney's Code of Conduct. Why do you need these? You need this because what you do at work affects the work of an attorney. And if you don't work in a law firm, you work independently. When a person looks at you, they look at the legal practitioner. And when they look at a legal practitioner, they expect a legal practitioner to behave in a certain way. And if you don't behave in that way, they start raising an issue on your professionalism as a legal practitioner. Whereas you don't have a legal practice act for paralegals, but generally speaking, when somebody looks at you, they look at a legal professional. And when they look at a legal professional, they expect you to understand the Legal Practice Act. I'm looking at the Legal Practice Act in front of me, but I know you're going to get yourself a copy. So if I were to look at the Legal Practice Act, Section 5, it will say 5C, to promote and protect public interest. And at D, it says to regulate all legal practitioners and all candidate legal practitioners. You see, it's talking about lawyers and law firms. And if you work in a law firm, or if you work for an advocate as well, legal practitioners in this context include advocates, you'd be expected to follow these rules, this code of conduct, this behavior, even though you are not. Because when somebody looks at you, they see a person working in a legal practice. And I've said this so many times, because it's very important for you to understand that you cannot get away with saying, I am just a paralegal, I'm not a lawyer, therefore I can speak anyhow. You can't. When a client looks at you, they see it a legal professional. Well, this is module 2. We're looking back on the learner guide. It tells you about introduction. It's aimed at learners who are doing paralegal, and I can see it says introduction to law. It shouldn't say introduction to law. It should say professional conduct. Unless I have introduction to law on me. If you look at this module, study unit 1, it takes you through the different courts and the different fora. Fora is plural for forum. So you'll understand that law does not only happen in court, it also happen in other fora. For example, it could happen at the CCMA. It could also happen at the community schemes, ombudsman, CISOs. And all those areas are the fora that you need to know how they function and how those fora influence law in general. You'll see that it also expects you to apply information from sources of South African court procedure to given scenario. There are different court procedures, and when we talked last time, we talked about you can find different rules of courts. And in the different rules of courts, we said you can find the magistrate rules. When you go back to work, and you can check and ask them to give you the rules. But there's also the superior court rules. All these rules, they tell you how a particular court deals with a particular thing. Were you able to find those rules? No. Okay, so find the magistrate court rules. They're available online. On the magistrate court rules, you're going to find something for me. You're going to find the notice of bar, the rule around notice of bar, how notice of bar affects court proceedings. You want to find out when is it issued? You want to understand its implication. Next, they say identify the appropriate forum for the resolution of civil and criminal matters within South African legal context. I think on Tuesday, we discussed civil cases and criminal cases, and we have explained this at length. But we said, if you look at civil cases, you're going to follow the rules of the courts. But similarly, if you're going to follow these rules, criminal cases function in a particular specific way. That way, we said, you're going to find where? You're going to find that way, at least in the Criminal Procedure Act. You have found the Criminal Procedure Act before. In the Criminal Procedure Act, you looked at the schedules of crimes, for example. But in that very same act, when a person is arrested, it tells you the manner of arrest. How should a person be arrested? But it also tells you, for example, after he's arrested, what should happen? He should be brought to court when? When he gets to court, he applies for bail. He applies for bail under what conditions? What are the terms of applying for bail? It tells you all these procedures and all these processes. Once you've understood these procedures and processes, demonstrate the knowledge and understanding of procedure in selected court fora. If you were to go to CCMA, what procedure would you follow? CCMA has got something called the rules of the CCMA, with its own rules and processes. If you're going to go to a housing tribunal, you'd probably have to go to the CSOS Act and its regulations. It's actually two small books that will always give you CSOS. CSOS Act, excuse me, and the regulations. And if you're going to ask for a prayer in terms of those acts, if you're going to say, I'm coming to CSOS to complain that my landlord is doing this, or that our estate is doing this, or things like that, if whatever you ask is not in terms of Section 39 of that act, if I'm not mistaken, CSOS will not deal with it. So it's regulated by certain rules, but it's got conduct like who should represent somebody in court. Is that person going to be represented by a legal representative? Is that person going to be representing themselves? Same as CCMA. First appearance at CCMA, can a person bring a lawyer? Generally, no. But how about it? Arbitration. What makes them to have access to a lawyer, and how should they access a lawyer? As a paralegal, can you assist somebody at CCMA? If you assist somebody at CCMA, what should you say and what should be said and what should be done? In which spaces can you work in? For example, CCMA is not always attorneys who represent people at CCMA, which they would, but you could actually be a paralegal who works for a trade union. If you work for a trade union, you would then go to CCMA and represent that person as if you were an attorney, right? And you assist that trade union. You could also be working for an employer organization. You could then go there and represent that employer organization as the member of that employer organization to assist the employer to resolve the issues. The understanding is perhaps you'll be understanding the industry and you'll understand the processes at the CCMA. But this is another fora which is not really a court, which you need to understand how it works. Demonstrate the knowledge of laws of evidence in civil and criminal cases. Why in professional conduct law of evidence is that now important? I mean, all along it was law. We just mentioned that law of evidence is one of those laws you need to know when you look at public law. But why is it important here? It's important here because one of the professional requirements of professional conduct is you will present evidence. And if you present evidence, the question is which evidence will you present and which evidence is admissible. And one of those things, by the way, is a person who comes on the stand and that person gets cross-examined. You say, but I won't do cross-examination, Mr. Pal, I'm not an attorney.
Those things that's there.
We just gone explaining that you may represent people at a forum. If you're now representing somebody at CCMA, you will have to do cross-examination. And I don't expect you to be a super professional at doing it, but it doesn't even start with asking questions. It starts with your behavior when you are asking those questions. Have you ever heard somebody say somebody's badging a witness? I said, answer, Road cop, answer. you can't do that. You need to treat the witness with respect. And remember, he's not your witness. And he's not their witness. He's a witness for the court. He's there to assist the court. And all of you are here to establish the truth. And you'd want to be cordial when talking to people like that. The language you use, the posture you keep, they're all very important in how you behave as a professional in a particular space. Star, if you can find me, I'm finding my paper module 2 somewhere here. So that okay. Please arrange me to get paper module 2 from. If it's not here, ask Mel. Well, we also need to look at the different areas of law discussed within a South African legal framework. We've discussed these areas. We've discussed public law. We've discussed private law. We have not discussed much around general support of public and private law. Having discussed private law, we have looked at a discussion last time that says private law deals with civil matters, which are matters between parties. So in most instances, lawyers will deal with criminal law because it involves matters that will necessarily go to, which will actually go to court. You would assist them to compile documents, but you will realize that in criminal law, you will not file lots of documents. There's not much for you to do. If you're going to file, it would be 1 or 2 documents, which would be on interlocutory steps. You remember last time we said interlocutory, it's a discussion in between. You probably file those, but it's not that very involved. Unlike if you're going to deal with law of persons, for example, family law. If you're going to deal with family law, you'd find that in family law, you as a paralegal will have to do a lot of runarounds. For example, you would have to go to court and file the summons, right? And from then, you probably would also you have already gone to the office of the sheriff. That's one of the first things you will do. And after you've done with those, you are going to have to take the copy of those summons and go to give to the opponents. And you would have to then come back with a stamped filing sheet and a copy for the office. You probably have to file it and inform the attorney that I've done all that needs to be done. Everything is in the file. Can you see the attorney is not very much involved. They've drafted and they're giving you to do all the runaround. The next thing, they have those discussions. They come back to you and say, well, we are having a settlement agreement being discussed. Here's a draft. And you take that draft back to the other parties, and the other parties would sign, give to you, and then you bring it back. Of course, in between, they would have had meetings, they would have done all those things, but you see, you are now involved. The next thing, that settlement agreement will come to you, you attach it to the summons. After attaching it to the summons, if there's children involved, you will take it to the children's advocate. If you're in Pretoria, you will have to go to Andre Street. If you're in Joburg, right in front of the High Court. I don't know what name of street is that. If you are elsewhere, I use of strong, Google it. So you'll have to find those people and take those documents there. Every time you handle these documents and the people you interact with, they expect professional conduct. You have to behave in a professional manner and behave in a professional way. The law relating to patrimony has got to do with your property, the things you own, like we discussed on Tuesday when we were discussing the introduction to law module, which went into detail. But what's going to happen with you and law of patrimony? What's going to happen with you and law of patrimony would be how to deal with the office of the master, the deceased estates. You're going to see on another module, I'm going to discuss with you deceased estates after June. I think that will be around module 5, 6, all those other modules. When we are dealing with deceased estates, we'll probably be talking about what a person owns, what he leaves his children. But sometimes it's not the person who has passed on. We're also talking about a person who's alive. If you've got your own assets, how do you own them and how do you get rid of them? If you rented out your house to somebody else and then that person needs to be evicted, how do we do it? Law of personality. How about if you've been defamed on the newspaper, on the news article? Like you wake up in the morning and a client calls you, say, hey, I've been on a newspaper article. They are talking about me and I really don't know what they're talking about. What do we do now? Do you sue the newspaper? Do you ask them to retract? What do you do? And those are the things that the lawyers will do. But before they do that, they will say to you, Sipo, bring me that newspaper article. When they say bring me that newspaper article, do you think we're going to sit down and want to read it? No, not really. I'm going to say, well, what does it say? So when I'm saying bring me newspaper article, I'm not saying bring me the paper. I'm saying bring the contents. What does it say? And when you bring it to me, you would have now underlined anything and everything it says about our client. And I sit with you and then I make you a sounding board. If I'm angry, I'm angry on you. So how can they say about our client that you must say, oh yes, boss, yes, how go see me? No, these people are not fair. You repeat the last word. Fair, hi, they are not fair. So what you then do is you are working on the, thank you. You're working on the law of personality, people and their assets and what people own. But in this instance, you're also working on law of personality. The thing that they own here is not a physical thing, it's their good name. In Sotho, they say, Lina la motho ke kgomo. In Zulu, igama lomuntu inkomo. In Afrikaans, the name for no, you forget it. In Afrikaans, it's the BSD word. So the name of a person is worth something. And that thing is a constitutional right to dignity. Remember that we said there's constitutional rights when we talk about every person must be treated with respect and dignity. There are other laws that are supplementary to private law. These are indigenous laws. We have talked about indigenous law slightly in your class on Tuesday. But on the 4 o'clock class, they actually discussed this in a little bit much detail. And they've actually looked at the Constitution and they say, well, this is actually in the Constitution. The Constitution recognizes indigenous law. It says indigenous law, it's recognized in our country in as far as indigenous law is not contrary to the Constitution. What does that mean? If indigenous law agrees with the Constitution, that law will remain law. The moment that law is contrary to the Constitution. Last time we talked about the case of Bay, right? You read that case? Or you said, yeah, as long as I've got the name. Read that case. I will find another one. I think it was also in Kayelitsha or something like that. It talks about Ukutwala. You know Ukutwala? Nothing. No wonder you guys don't have 3, 4 wives. You Ukutwala is a practice in Eastern Cape where a guy or even his friends and family, they go and find a girl they like and they take the girl and take into a house and lock her up. Yeah, literally. Yeah, they'll lock you up. Lock you up in a house. And they will go to the other family and give them the cows and everything. That's it. You're married. It takes away your rights, freedom of choice, takes away many things. And in this case, I'll find for you, if I don't forget now, the girl was underage. It also brings other issues of statutory rape. And it happened a lot, and it happens still a lot. It's a culture in the it's a Xhosa culture, but I know that the other cultures also do. The Sotho culture also does it. Southern Sotho, Bashubedis. Have you ever heard of something like that? Telling you, be careful. Walk with a nokapi in your pocket. Somebody might tell you right now. It comes from indigenous law. That case said the practice of utwala, it's unlawful and thereby unconstitutional. I'll find that case and make it available to you. Private international law helps to determine which legal system laws are applicable in cases where legal objects from different countries become involved. Can you see, we talked about international law in the other module, right? But in this module, they've added something to that international law story. They've added private. Can you see? Private was not there when we discussed it. So they've now added private, and they say private international law. What does that mean now? International law is the state against the state, South Africa versus Hamas. You remember that story? But there's cases where somebody is born in South Africa, the mother and the father are Zimbabwean. The parents die, and the person doesn't have an ID. Now what? Can the person be sent back to Zimbabwe to get an ID? Yeah, maybe, but arrive in Zimbabwe and say who? You know nobody in Zimbabwe. I mean, so the best Zimbabwe you can find is which one? The embassy. You have to go to the embassy because it is in South Africa. They will assist you and all of those. What happens if your embassy doesn't want to assist you? Your attorney now has a case against Zimbabwe and then gets a case against South African Department of Home Affairs, and they deal with those situations, and that is that. But what happens also, the examples are there. What happens when somebody divorces in a foreign jurisdiction? I know this for a fact that I have included a discussion around the letter of authority in one of the modules. The reason I've asked Mel bring us the paper book so that I can now look on the other side without scrolling on your book. So that module is module 7, deceased estates. In that module, I have put in a discussion around what happens when somebody dies overseas and their assets are now in South Africa and that person is in a foreign jurisdiction and they obtain a letter of authority in a foreign jurisdiction. Can that letter of authority be used in South Africa to dispose of the assets of the deceased? If we are saying no, based on what? Then what should happen then with that letter of authority? When you do module 7, you realize that it's not about text. It's not like this. It's not a lot of words. It's actually a lot of documents, a lot of forms. It's lots of regulations I've attached there. I've actually said a little bit on text, but I've put a lot of documents for us to go through. In some of the modules, I've not done that. And where I need to do that, I will do that. I cannot refer you to that module now for you to see this example because I will be dragging you into next semester. So to avoid dragging you to next semester, I will use that as an example and say, guys, it happens that somebody dies overseas. There's a letter of authority with his family overseas, but his assets are actually in South Africa. And when we are now discussing this international law, it's not international law between the states, it's private now. It's international law that affects you as a private individual. General support of public-private law. There are other fields of law which have developed in general support of public-private law. These include interpretation of statutes. I'll explain this in a bit now. Forensic medicine, comparative law, philosophy of law, jurisprudence. We have done philosophy of law. We have discussed Ubuntu and say it's a legal principle and all of that. I'll come back to it. Legal history. We have done legal history in the other module, module 1, isn't it? So let's go to the first one. Interpretation of statutes. What is then interpretation of statutes? Interpretation of statutes has to deal with how you interpret a legal principle. Sometimes, first and foremost, you interpret something based on its dictionary meaning. And the teacher told us to submit our assignments 1 o'clock. The way to submit would, in the context of assignment, mean to carry your assignment and make sure you find the teacher and you give the assignment to a teacher, right? So you've printed it, you've signed it, it's done, it's finished, submitted. But submit your assignment in the context of an assessment you've done online could also mean to click the send button, or if it's a quiz, to click finish by 2 o'clock. It's not correct for you to say, well, I have finished and I had to travel to bring my assignment to you and there was traffic jam. That is why I did not submit it on time. If you are telling me about a written assignment on paper, your argument is correct, right? We should accept that there's traffic jams, there's load shedding, and there's other things. But if we are talking about you pressing submit online, what does it have to do with the traffic jam? It's got nothing to do with traffic. What I've just done, I've shown you the interpretation of submit in context. First, I give you the definition, is to send and give to somebody. But secondly, I'm giving you the context. It depends on the situation. Huh? So it depends on your situation. If the situation is submit online, submit online. Like if you write UNISA exams, you have to click send, my friend, on the given time. Otherwise, we are so not marking it. If you are doing, having to bring it to the office, bring it on time. Don't wait until the last minute, but we'll understand that there's traffic. If you're submitting it online and there was load shedding in your area, we'll understand that there was load shedding and we can check the load shedding schedule. There was load shedding. That's why you didn't submit, because just after you wrote, load shedding hit and you don't have a backup generator. But if they say before the exam, make sure that you go right to exam at a place where there is a backup system. You also, in that context, cannot rely on that argument to explain why your assignment or examination must be admitted late. We just interpreted submit, right? It's important for you to understand that there's an interpretation of things. What does this have to do with you in real life? In real life, this is what's going to happen. I've said to you, go find notice of bar. In reality, you're expected to go submit you're supposed to go submit your plea to the other party. on a given time and date, and you'll see those times and dates on the notice of bar. Probably will say 5 days, and you don't do it, and then they go to court, they get a default judgment, they go right along, and then you now go and review this case, this matter. I've now explained to you what matter is. In applying for review, you want to go to the court and say, well, I was on my way to submit and I didn't receive my documents. Then the court will say, well, did you even approach your colleague to say to them, can he condone your late submissions, and what were the reasons? Say, no, it's just that I had emailed it to him and I was about to give it to him by hand later. The court rules, do they allow you to bring the plea in paper, or do they allow you to serve electronically? That's where the rules apply. Professional conduct influences all these things. How you interpret serve, how you interpret file, he shall file with, depends on what you are talking about. If, for example, you are in Gauteng, this could simply mean to load that document on case lines. But if you are in Mahikeng, it will mean taking that document to court by hand, get it stamped, and take it to your colleague. Interpretation of things, right? They depend on the actual factual weight, but they also depend on the context of it. There's a whole course on interpretation of statute. It so haunted me that I even know the color of the textbook is green. And I can see that it is going to kanyada like or basinyada like at the front. Interpretation of statutes. Now, forensic medicine is what paralegals will also be involved with. If you're going to do, guys who are doing road accident fund, you've done this, right? You take the client somewhere to be tested by a doctor. I think you actually start by going to fetch medical records from a hospital. Isn't that what you guys do? You go to the hospital, fetch medical records. Hey, you meet those uncles who work in slow motion. Hey, the greeting is very slow. Hey, yeah. Ivieta. Opadets. Those kind of discussions. They're like, ish, my bra. Can we like move it right along? Be nice. If you're not nice, your document will be put right at the bottom of the pile. So candidate attorneys, you'll interact with forensic medicine in your own space. But why do we need forensic medicine? We need forensic medicine as evidence to prove injury, as evidence to prove damages in road accident claims, medical negligence, and other fields of law. But your role is very important to understand that in as much as somebody else will interpret these things, it's important that you bring the right document. You also go to the hospital to get medical records. You know that you can come back with an incomplete record. Make sure you get the right thing. Eh? Because if you don't get the incomplete one, another 3 months. Just make sure. If they say to you, go to the hospital and get medical records, perhaps look at the sample of the medical records on another case and see what medical records are we talking about here. And ask the attorney to write you a letter, that covering letter that you should go with, so that you can go ask for the right thing. I'm warning you. Comparative law. We've discussed comparative law when we discussed in the previous discussion. I won't go into it. Philosophy of law and jurisprudence, we've discussed them. Legal history, we've discussed it. I've put for you a table there where it shows you the main areas of South African law. and what you find in each type of law. I'm going to move you into what I'm moving there on the screen. I'll probably move you to the concepts of substantive law and formal law or compare. So let's talk about substantive law and formal law. First, formal law is what you would call procedure. So there's procedural steps. The substantive law is what you would consider facts of the matter. So when you're discussing the law, you are then discussing the law based on what needs to happen. So just to make things easier for paralegals, let's do a criminal case and let's do a road accident fund case. A road accident fund case is a civil case, and murder is a criminal case. So road accident fund case. If you're going to deal with the road accident fund, you need to do the formal things first. So what do? You go meet a client and you make sure that that client signs the mandate, right? Probably that client comes to the office and he meets you and the attorney involved or whoever senior in your office. But in most instances, in some instances, we'll ask you to go fetch that client. You need to explain to that client. You need the original ID so that we can make copies and photocopy them. You need to bring any other documents you found at the hospital. You need to bring the accident report if you have any. If the police station is nearby, can we drive by and check if we cannot get it, or at least have contact details of a person who's got this? So what are we doing here? We are gathering all these formal documents so that we follow procedure here, generally speaking. So the first formal thing you're going to say is your firm must get a mandate, and the firm signs a mandate. And I think including those, they make them sign also the termination of mandate form if there's any other mandate with RAF or anybody else. So those forms, part one, done. So the first group is the mandate forms. The second group of forms is the road accident fund forms, right? You then help them to fill the forms, check the names, and the attorney, probably the candidate attorney also is there. You guys fill the forms and make sure that the forms are filled how? Properly. The address, if possible, you ask them to give you proof of residence. The address is the right address, the banking details of the law firm and everything else is all there done. Must you now take these forms to the, when must you take these forms? Can you keep them in your office for 5 years and then take them later? There's prescription of when they can be taken, right? If it's in a hit and run accident, how many years? 2 years, I would think. Check the road accident fund. In 2 years, those forms must reach the road accident fund offices. Check the prescription times. If the matter is the driver is known, 3 years, I would think, because prescription is generally 3 years. So find those rules that apply, write them up the wall, put them in your diary right there, make them your screenshot or screen what in front of your screen on your phone. So see it, dream it at night, know those things, because if you don't do it right, you file those forms late. No matter what the injury, no matter what the thing, the matter has now prescribed. You say to me, but Mr. Pal, who cares? It's 3 years, guy. 2 years. We have 2 years, most. Are you saying in 2 years I will not pass by main lane? Well, the person could be reporting to you this road accident that happened, hit and run accident that happened 1 year, 10 months ago. Do you see that your 2 years is not really 2 years? Because it's when the accident occurred, not when you are filling the forms. That is why you went and you checked the accident reports to see the dates. Right now, are you arguing he was injured here, he was injured there? No, 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 no. You are doing the formalities. When did the accident occur? You start counting. By when should we file these documents? Thereafter, by when should we file the summons? I think 5 years or something. Check on those rules. It's very important. Well, the summons story, the attorneys at the office will have to deal with. That's their fault. But in your situation, if you arrive and you have collected the documents and you have looked at the road, the accident report, and you have seen that this thing is like 1 year, 11 months ago, and then you put it on my table and say, oh, Mr. Palace, I've put a file there on your table. Nah. Me, think I'm going to look at it. No, I've got other things to do. 1 month, 2 weeks, the matter is now prescribed. If it is like that, send me a WhatsApp, slide into the DMs right there and say, there is a situation here, Brian. This thing is going to be prescribed, as Mr. Pala told me in the classroom. Do something. Then we can find any other attorney in our office, or we can find a colleague, or we can refer to another firm who can help if I am busy skiing in the Maldives. And I'm eyeing that ski in the Maldives. Just make sure that this matter gets handled properly. The forms are filled, they are filed on time. What am I talking to you about, really? It's about formal things here. Procedure, Brian. The same thing applies with a criminal case. The client gets arrested. The next thing you want to do is do what? Make sure that you go see him. When you see him, the discussion is not what he has done, how long will the trial be. That's not the issue. Right now, we are sitting right on top of bail application. Yeah. You go to the schedules and check, what schedule is this? Because there's a procedure. You remember you told me that some bails can be done by the police and some bail cannot be done by the police. So you need to understand these things and follow procedure. You cannot take your client to court on an application where that bail can actually be done by the police. The court will say, but you should have done it there. And remember, if your client is arrested on Friday, what are we talking about actually here? Monday, yeah? So, procedure. You say, but Mr. Parliament, oh, I'm a paralegal. Am I really going to get worried about this? I was over strong. The attorney will see to finish. No, because if he calls the office and you pick the phone, you need to establish those basic things. What were you arrested for? Don't say, what did you do? That doesn't help. What were you arrested for? Because when they arrest him, they say to him, you've got the right to remain silent. We are arresting you. They give him what for? For drunken driving. For they give. Say, what did they say? I'm not sure. Ask them. Who arrested you? You call that officer. What were you arresting him for? Then, Mr. Pan, he was arrested for XYZ. Then when I drive to the police station to see the client, now I know what to do. Even on my way there, I start to make phone calls. We need an emergency bail. If it's that client who's disabled, who's got a disability, and he cannot function without his medication, he needs a wheelchair, he needs he needs what. His situation cannot survive Saturday, Sunday in custody, can it? There must be special things that needs to be done in between. So persons with disability might be treated very different when you go to situations like that. But you call me, you don't say, you say, well, your client Sipo is arrested. I've got 5 clients called Sipo. You better say your client Sipo, that gentleman on a wheelchair is arrested. Then I've got a problem. That gentleman who was in hospital last week, Friday, then I've got a problem. I have to check, Sipo, do you take any medication? I go to your house first, fetch the medication. You say, eh? So you go fetch his medication? Yes. Because this life now is very important before I can even think of bail and other things. So as a paralegal, you need to know these things. And you see, In a criminal case, the formal thing is I'm going to apply for bail, but what type and what are the prevailing circumstances? And I've talked to you about interpretation of statutes, right? And I've said to you the context matter, contextual interpretation of things, they matter. When going to have to apply for bail, if it's a certain schedule, schedule 6 is, probably he needs to make an affidavit, appear before a court and all of those. But another thing about these is he has to prove his address. One of the things that is notorious is you go to court, you arrive with your client, the investigating officer says, well, we have not established his address. If the matter can be postponed for us to establish his address. No, guy, no. Just there and there, talk to the investigating officer, make sure that the address is established, get proof of residence if you have to. Because you understand the procedures. Bail, if it's a bigger crime, involves money. Call his wife, go get the money. Some courts will literally swipe a card, but some courts do not. Caution the wife and say you need cash. Caution the husband and say you need cash. Those are practicalities, right? But formal procedures in bail applications will require certain steps and certain things. For example, he must not threaten people. He must not say, give me that phone, give me that phone. When I get out of here, it doesn't help because the formal procedure will require that he doesn't interfere with witnesses. Those kind of things. So we send you, okay, quickly, go to the police station, see the client, I'm on the way. When you arrive there, you want to safeguard those things. But have they checked your address? Don't fight with the policeman. We'll sort this out. Don't intimidate anybody else. We'll be okay. We'll get you bail. Reassure the client. Have you got your medication? On a wheelchair, are they taking you to a specific cell where you can be comfortable? On crutches, is the cell not overcrowded? Are you able to move? Well, good luck with overcrowding, but something like that. You remember the Oscar Pistorius case where they had to take him to some children's jail cell or something, it was said, in Brooklyn, I think. Why? There's a person with disability, you put him in a bigger space, he won't be able to move for starters. So those are the things that are important. So I'm reading from your book. In the next 5 minutes, you'll go drink coffee. Just make sure it's not Irish, and you'll smoke something. Just make sure it's not a cabbage or something like that. Green, anything green, just stay out of. Spinach, don't smoke. Smoke brown things. Set down the procedure that can be taken once a right has been violated or a duty has been breached. It tells you the bail conditions that must be followed. It tells you the forms that might be completed on the road accident fund. It's not any other form. There are specific forms. Even at CCMA, there's specific forms for you to fill. Prescribes what evidence is needed and will be allowed to defend a right to prosecute a breach of duty. For example, for you to be released, we should know your address. We said that. So it's one of those evidence. You could be able to say, okay, here's his proof of residence. And here is his auntie who has now deposed an affidavit. It says, Uhlala nam, and she's stamped at the police station. And here she is. She's willing to testify now. Here's proof of his children who are going to school and they need school transport. If they don't have school transport, which he pays for after he's selling sweets in the corner every day, these children will not make it at school. The rights of the children are far more important. So you need all those things to assist you with a bail application. Well, we throw in something I've told you in the previous module. We said transplantation of law. when the law was carried out by certain guys, we were talking about Jan van Riebeck and people at the Cape. You can see now they're also saying that the procedure here has been brought into South Africa by English law. Substantive law is a different concept. And when we return from our 5 minutes break, from smoking brown things, as somebody says, well, you can also smoke that small computer that, what are they called, those small computers? Yeah, the small computers smoke. Yes, like Elemente, I'm watching you. Even on that small computer, don't put things that have got a virus. I'm watching you here online. Okay, take a small break. You should be back 10 past. Yeah, be back 10 past, man. Stretch your feet, find something. When you come back, I'm going to tell you about substantive law. Maybe while you're on that small break, find yourself the magistrate's rules, if you can, please. Thank you. Small break for you. Ladies and gentlemen, we should be back. Star should be locating coffee. You'll hear me raising protests about coffee not arriving on my table and things like that. I hope you got yourself a good cup of coffee. Those who smoke e-cigarettes, they call it. I've been told now those computers are called e-cigarettes. You are able to smoke from your small computer, you know. And my coffee has just arrived. So it's happiness. It's a very happy day this day. We're supposed to do the next session until 11. Okay. And we are now looking at substantive law. It will be strange that when I was discussing procedure with you, I discussed procedure using substance. So where you see the word substance, think facts. So substantive law is factual law, is the facts that are there. While procedure tells you what you must do, what procedure tells you is how you must do it. Substantive law tells you what you must do. So the word of the law, for example, you want to prove that your client is residing in number 21 Brongerspruit Road, Silverton. You need to produce proof of residence and some form of affidavit from his wife to say that it's indeed my husband and we reside at this address. It must be substance, something in layman's term we say something tangible. If you're in Eastern Cape, they will say there's something you hold on your hand. This is it. This is my proof of residence. In all matters, let's go back to the criminal case. So in the criminal case, you used proof of residence. They arrested him without an ID. Maybe he's a little bit dark like me. And they say, you vendors from vendor, you are half Zimbabwean, half South African. Are you really South African, you? Hey, I'm a South African. Hey. Where's your ID? Hey, Andina ID. Hey, Puti. He needs to produce what to prove? An ID. You cannot produce, say, I'm telling you, I go to church. I'm telling you, it doesn't help. You need substance. You need the actual, not even the copy of it at this instance. You need an original. Yes, my ID. Substance of things. What does that ID do? It gives you the benefits of being a resident, isn't it? It confirms your rights. And you also now have a duty to pay bail. You need substance. You need to prove that you can pay bail. You say, here is my pay slip. I'm employed. Here are my banking details. Given a chance, I will go and withdraw the money and I'll deposit the money with the court. Here is the substance. I cannot run away and go to Mozambique. Now that you establish I'm not Zimbabwean, who knows? Maybe I also have got a Mozambican passport. And I now surrender my South African passport, or I don't have a South African passport. I was caught up in that kind of 2-6 situation where they say, well, your client has a passport. I say, no, he doesn't. So what do you do? Can you say, your client has a passport and you say, he doesn't? They say, he has, he doesn't, he has, he doesn't. It's not going to work. One of you needs to produce records from the Home Affairs that say the client does not have a passport. And if he has got one, the since been cancelled. If it's lost, he'll get an affidavit that says the passport was lost. This point 2 provides a means for the protection of the rights and duties. As a South African citizen, he's got certain rights now. And these rights are now being protected, you see. His duties as a South African citizen is to make sure that he will now pay his bail and he will attend court on a given date. He is warned by the court. He has got a duty to find a legal representative, isn't it? The court will say to him, are you going to use legal aid or are you going to get yourself, Mr. Pala, if you've got big dollars? If you don't have the big dollars, find legal aid, because you are South African. You're supposed to be held by the Justice Department. I will give you an attorney from legal aid. Oh, who knows? The very same attorney from legal aid could still be Mr. Pala. Because the same attorneys that are they practice privately, at times they also practice for legal aid. So it doesn't mean you get inferior legal assistance. It's just that you cannot afford this side. Go this side and get help. Please. I'm warning you. Don't be that guy who says, I will represent myself. Big mistake. Roman law focus on substantive law to define and protect rights and duties. Remember you and me talked about Justinian? And we talked about he codifying documents, he's making rules and all of those things. That is why the things I'm telling you about, I'm saying, go find the magistrate rules. They are codified, they're written down. I can't change them, you can change them. They are what they are. Notice of bar, 5 days is what it is. It's not, I can't do anything about it. You can do anything about it. All you and me must do is comply. So these things are written down, and they came back. If you remember Justinian in the other course, they come back with the concepts that you will find that substantive law is mostly codified. It's written down. If it's not even written down, when you go to court, if it's a big case, especially in civil cases, there'll be practice directives. The court will issue a directive. The court will say, you need to do the following things by this day. Let me also be very clear. You need to file your affidavit by this day. You need to file a response by this day. You need to file a reply by this day, if any. You need to make sure that the court file is paginated by this day. You need to be in court by this day, all of you. So this directive is very clear. It tells everybody what needs to be done. Can you see at the bottom of your page, they are giving you an example. They are saying substantive law and formal law. You can find the distinction in this thing. Substantive law talks something like private law, law of persons, family law. It simply says how to institute a divorce, how to get the rights as the father of a child. But all of these things do not happen unless you follow court procedure. You need to issue summons by the sheriff. If in a divorce matter, family law, there is no return of service, that case will not go any far. One of the things that is going to be required there is that the other party has been served. And you cannot get away with it, because the effect of divorce is it doesn't only get parties divorced, it completely changes their lives. Man, it even changes your surname. I know you. You want to marry and your surname becomes Simon Mahlangu Mandela. I'm watching you. Because now you want to piggyback on the Mandela surname. If that Mandela girl divorces you, bruh, you're Simon Mahlangu one time. No VVVIP tickets anymore. Libel. So that is the situation. It has got also in effect on your finances. Because now you and the Mandela girl now, that joint account you used to have, it has to be closed now. Because you're now two separate entities. That house you owned, it has to be sold now. She takes a half and you take a half if indeed you were married out of community of property. Civil law controls how individuals behave towards each other. The innocent party must institute action himself or herself. Can you see now what your book is doing is taking you through professional conduct in civil proceedings. And it shows you in civil proceedings, professionally, for you to institute a civil matter, this is what you must do. It says, the party instituting proceedings must be the one to start the process. And if they are issuing summons, this person will be known as the plaintiff. If they are issuing affidavits, applicant. Well, the other party who receives these documents must now respond on a given number of days and respond to what they are now receiving from the other party. They now become the defendant or they become the respondents. What they usually do is they do not immediately respond if they're a defendant and all of that. If they're a defendant, they would issue a notice to defend. So we will defend. Wait, we are still drafting. And in application procedure, they say they will issue the notice to respond to the matter. Then they'll respond to the matter at the later stage. So the notice will be called the notice to oppose because they are now opposing the case. If they're not opposing the case, they will then issue another notice. It's called a notice to abide. It happens mostly if there's adjudications. The parties who went to an adjudication are taking it to court to review this. The adjudicators would always file, most instances, file something called the notice to abide. They say, whatever the court decides between those two, we will agree with it. And then the matter will go before the court if the issue, and it's a little bit tricky discussion I'm bringing, if the issue is not the substance, the issue is only the law, the matter would be an application procedure matter. But if the issue is the substance, it will now be an action procedure. So let's illustrate. If there is no dispute that you owe Mercedes-Benz 300,000, you agree you owe them, but the only issue is whether Mercedes-Benz should repossess your car in law or whether they should demand the whole 300,000 from you. It becomes something that you want to claim in terms of the credit the National Credit Act to say they have not given you a letter, say in 20 days pay, and you want to dispute that thing, and they've sent the documents. When they send those documents to you, clear smack bang ding, here you are, here's the application, and you don't dispute, clear argument, here you are. You go and say, this is a legal argument, this is purely application. And it's even that simple. The court will not even call you to court. They'll determine this on paper and send you guys the decision. But the moment we are going to argue whether you owe them 350 or 300, can you see there's an argument effect here? You will produce proof of payments to say, well, I paid, and this one says, and the other one says, I never received it. The other one says, I was with my secretary, we arrived and we paid, and I saw Sipo there. Sipo must be called as a witness. This won't work. This requires action procedure. And then evidence will be adduced, evidence will be rebutted, evidence will be admitted, evidence will not be admitted. So all those processes will follow under action procedure. For you to understand public law, you can simply use a diagram. There it is. The supreme law of all is the Constitution. If you're going to interact with government, there will be administrative law. And then there'll be criminal law. There'll be international law, both for the states and for private persons. In this book today, you've seen that international law can also involve private persons. There'll be substantive law, where the facts are dealt with. There will be formal law, where two procedures can be dealt with. One procedure can be for criminal matters, and one procedure can be for civil matters. The procedure, interestingly, if you're looking at Criminal Procedure Act, it tells you how the criminal procedure should go. But there's also procedure on how evidence must be presented before the courts. If you're going to present a expert witness, he must be an expert, and all these rules apply, and all these rules apply. You cannot find anybody and say, my bra, you work here at VW? He says, yes. What do you do? I make coffee sometimes, Parayak. Mara, you know cars. Yeah. Me, I know GTI. I know golf. I know, I know these cars. Okay, sharp. You're going to be my expert witness now that these guys have messed the gearbox on my vehicle. Let's go. Monday, ne? Monday. Don't disappoint me, my bro. You must be there. And this guy arrives there. He's an expert. I like the coffee they made, but I don't think that this coffee will solve our gearbox problems. Right now, you need a qualified engineer. He must first tell the court his qualifications, not Brayaka Simon. Thanks for the coffee side, but Brayaka, you're not coming with me to court on this situation. It's too late. We need the engineer. So, can you see? I'm not telling you what the engineer will say in court. I'm just telling you procedure. The person must have a qualification, must be a proper engineer, certified. Otherwise, it's not going to come and say things like that in court. I've put for you an example there. And I say to you, constitutional law. Guys on the chat group, please type there, tell us, who is the Chief Justice of South Africa? And somebody tell us, who's the Deputy Chief Justice? And what course do these people work in? Maria, who's the Deputy Chief Justice? Come right there in the chat box while I'm sipping coffee. Yeah, you can tell me, you can unmute and tell me, Maria. Honorable colleague Maria, unmute yourself and tell us the Chief Justice. Aha, Mandisa Maya, Raymond Zondo. You agree, Maria? That's Raymond Zondo. So you are aware that Mandisa Maya is likely, she's at 99.99% that she'll be the next Chief Justice. And you guys would have made history. So I feel like making history of things. They work at what court? In class, what court do these guys work at? The guys in class say they work at the Constitutional Court. Ah, Nolutando, you agree with them. I always doubt these guys. You don't know about these guys in class, Nolutando, eh? They don't smoke any computer cigarettes, nothing. These guys, they are sitting here sober like judges. All right, now that we have resolved that situation, we are looking at a court called the Constitutional Court, but the Constitutional Court carries matters in the constitutional law. But interestingly now, have you realized that the Constitutional Court is not the only court that actually deals with constitutional cases? These constitutional cases, they start vroeg in the more as good as the High Court. Actually, the whole situation can even start at the magistrate court, the regional courts. But the people who will pronounce on these constitutional issues, they could even start at the very High Court. It moves over to the Supreme Court of Appeal, and it moves over to Constitutional Court. But when people are discussing constitutional things and constitutional rights, what do you find in the Constitution? Well, the Constitution first tells you what the state is, who's the state, how is that state constituted. It tells you that South Africa has got the executive, has got the legislature, and all of that. You find it in the Constitutional Court. The authority the Constitution has, it tells you all of that. So we've given you a list of what the Constitution is. How are you going to figure this out? You go find the Constitution and you look at the index thereof. What are the things that the Constitution is actually talking about? And on chapter 2, for example, it talks about the rights of the citizens. But it tells you about, chapter 9 tells you about institutions. It's easy to cram those two in. Chapter 9 institutions, you probably think the public protector. So it has got those situations. The Bill of Rights is in the Constitution. It is the one that everybody, if somebody's arrested, the first thing that happens is you've got a right to remain silent. That is section 35 of the Constitution. The next type of law is administrative law. The administrative law deals with how the state primarily will exercise its power. For example, Promotion of Access to Information Act 2 of 2000, the PAIA. You've got the PAJA Act and all those acts that influence how the state will regulate its people. If I'm going to apply for an ID, Promotion of Administration of Justice Act 3 of 2000 is the one I always refer to as PAJA. If I'm going to apply for my ID, where do I apply for my ID? When do I expect the response from the government? What is likely to be the response? What happens if the government does not give me the proper response? Who should I complain to? Who is accountable? Who is the administrator? What action can I take to enforce my rights? All of those things are found in administrative law. Criminal law, my friends, we have spoken. The tribe has spoken so much about criminal law. But just to make sure, the state institutes actions against the wrongdoer in criminal law, not you. You only complain and say, he has slapped me. Undibethile kaloku uDJ. And then the police come and arrest the DJ. And then tomorrow you say, I was playing, the DJ has not bettered me. And they withdraw the matter. Are they withdrawing the matter because you said hi? No, they're withdrawing because they don't have a witness. But practically, if they have another witness, whether you say I can't betang, it's too late. Don't follow that evidence. Public international law. I've talked to you about jus cogens last time. I said a jus cogens is a law that is peremptory and the states must follow it, and they agree to follow that law and they live by that law and is binding on all states. Then you've got conventions, you've got international norms, you've got humanitarian laws. For example, in war-torn areas, there must be food. The children must not be injured during wars. Women and children must be protected from wars. What you've looked at, and I don't want to skip over to this where you and I will talk professional ethics. We'll do that on Tuesday. What you have looked at is a situation where law, as you have seen it in the introduction to law, it's not only just law you know. In introduction to law, I help you to understand and know the law. So it's the law you know. But in professional conduct, it is the law you apply. You see the difference now. At the beginning of the module, this module looks almost the same. But the moment you move right down to it, you realize that the nuances, the things that we are trying to get you to see, is that law is not head knowledge. Law is active. So you need to be able to apply the law. But when I talked to you about interpretation of statutes, I've also demonstrated to you that law cannot be applied blankly or bluntly. Law should be applied in context, meaning you must consider the circumstances in which a situation happens. And in those circumstances, you then need to apply the law. So this is what happened in South Africa. A sport athlete shot his girlfriend. No more allegedly. He shot her. And this sport athlete was given a sentence which was much lesser than anybody else could have received. The National Prosecuting Authority appealed this thing, and this sport athlete received now a bigger sentence. The sport athlete now went to jail, and he's now out. The question you must address on the chat group and in the classroom as you talk to each other is, was it correct to give Oscar a longer sentence, or that sentence which he received from the first time, given that, well, he's a person with disability, that the evidence was not that 100%, or whatever the story might be, whatever is in your head, you know the Oscar case. Discuss with your colleagues in class what you guys think about it, and discuss in the chat box. I'll also give you time to discuss. People in class are looking at the they'll be looking at the chat box as well and see what you guys are saying, but have that discussion. By the way, you can also unmute yourselves and have that discussion. To unmute yourself, do not wait for me to, you raise your hand and I'll mute you. Just unmute and have a general discussion as if you are sitting right in front of me. Start talking, guys. Say something. For starters, ask each other if you know Oscar. Do you know that guy?
Hi everyone.
Ah,
I'm
yeah.
Novazi. um, Speaking of the case of Oscar Pretorius, I'm still finding out how he forgot that his girlfriend was at the house. He thought it was an intruder. For me, I feel that it was well planned. Maybe jealousy, but I believe that. At the end of the day, justice will really find a good judgment towards him. And in most cases that I've picked up, that people will always try to move to medical condition in order to get away with the findings when they find guilty. Well, I don't know. Tell me, what do you think, guys?
I feel that he, like, just like anyone else, I feel as though he was supposed to serve as harsh, like, it doesn't matter how harsh, like, his sentence was. I feel like he was supposed to serve, like, his full sentence, because at the end of the day, when he did commit the crime, he was still the same disabled person. That didn't, like, stop him from doing whatever gruesome act he committed. So now, why should it be a factor when it comes to him serving his actual punishment? At the end of the day, she won't come back.
Okay, guys, what do you think? I'm hearing ladies defending this situation.
Case was party and best. That's the reason why the first judge like gave him 6 years, 7 years. And I feel like because of, I think it was more political issue than a law issue. Because of the politics of it looked bad. That's why the MPA decided to go and give an appeal. That's how politics plays a role in our law. So
Yeah, legal philosophy comes to play. So if there was no TV and everything else, you could have got away with 6 years. Well, interesting on the disability though. When he's committing this crime, he's thinking about it. He's planning it. And I don't want to sound very bad, but he's planning it in his head. That has got nothing to do with the actual disability he's relying on. Unless if we said he had a mental issue or mental illness, or he oversmoked the computer cigarette, something. but where I'm sitting, walking and thinking, two different concepts. Yeah. Well, yes.
But how can I say it? A psychometric test was done with a psychologist, which stated that due to past traumas of his mother, I believe, could have caused him to do such. So we need to take that into account.
But he had mama issues.
So he had mama issues, they say.
Possibly. No, the trauma from it. I'm not sure about it. I didn't follow the case as much, but I heard something like that, that past traumas would have led him to do such out of fear.
Me, I'm traumatized. You know, I grew up very poor eating cabbage, but I've not robbed the bag yet.
But that's not trauma. That's not trauma.
So it could have had an effect. Maybe that's why then Mema Sipa gave him 6 years, yeah?
Possibly.
Well, it's one of those issues. Ladies and gentlemen, thank you very much for the discussion. You've earned yourself a 15 minutes go home early, unless there's an issue that you want to raise. Anybody else in the groups, if there's in the chat groups or by microphone, is there any other thing you want us to address before we go? Who's that person standing on the side and say, hey, don't say anything. We want to go. don't say anything. We have to go, guys. No.
Sorry, this is Paleho Mudise. I kind of like missed 30 minutes of this session because I was struggling with my laptop. Is it possible that maybe I can get a recording of this?
Yes. Marilyn is listening. She'll be able to arrange and take it from there.
Okay,
On,
thank you.
on the 19th, Star, 19th of what? Is it next week? Next week, Tuesday? Next week, Tuesday, I'm having court, so I won't be around. You are welcome to attend a session online, which is 5 to 6. So I won't be able to do the morning session with you. I'll be drinking coffee in court. I wish. All right. Thank you very much. Thank you very much. We'll make the recording available. Anything else? What is it, Standiwe? You're speaking sign language there?
Sorry, does that mean everybody have to join the evening session on Tuesday?
Please, if possible, join the evening session, or otherwise get access to the recording of the evening session.
Okay. And exam-wise, are we writing exams?
We will write a summative exam, yes, but we'll also do a formative exam. For formative exams, the first session will help you with them on a Saturday. That's why we call those activity sessions we did. The last one, we actually did a lecture on it, but the next ones will actually be doing the actual activities and helping you through the activities. The first one, I'll be here at the Leeds offices in Pretoria with people here, and whoever else can come through, and we'll also be broadcasting it online. And I think if it's things we need to write and stuff, we'll have the video on, so you'll be able to see what we are doing and what everybody in class is doing. You can join and participate. It will help you with writing the exam.
Okay, thank you.
Are we all good? Should we go?
Yes, we could. And for my classmates, if you want to check the recordings, you can log into the lead website where we get our notes and go to Webness. That's where you'll find all the recordings to help you to catch up with our sessions. Thank you.
Perfect. Thank you. All right. We good to go. See you at the evening session next week, Tuesday, or get the recording there off. Thank you very much. Goodbye.